Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an awesome Saturday. Wait till people chime in. What is good, everybody? So, this is if you own, well, I said on. If you're on standard time, then this is kind of like your lunch time on Saturday. So, maybe y'all are at work, maybe y'all are cleaning up around the house. I'm in the process of cooking, so I'm just kind of going back and forth with you guys. But we're just going to tap into this real quickly. As you all know, Champagne Papi, aka Drake, aka Paperwork Papi, filed a lawsuit against UMG, Universal Music Group, and Spotify, just making claims that they boasted Not Like Us by Kendrick Lamar to a point where it overshadowed him. That's what I'm going to say. Hey, but are you getting ready for work? All right, well, just tune in. I ain't doing too much, just about to go over this lawsuit and then finish doing what I was doing for today. But yeah, hello, Marlena Davis. How are you doing? Welcome. Yeah, I'm not going to keep you guys too long. I'm just going to, I had it scheduled for last night, and then I was like, okay, let me go ahead and reschedule that. One, I was tired and I was working, and so we're going to get through it. I'm not going to really kind of, give you guys the backstory because normally that's what the petition does. It kind of gives you a background history of exactly, why we are here. And we are going to get into Spotify's response. Exactly. He's not like us. No, sorry. And it's sad, but I used to be a huge Drake fan. I kid y'all not. And then some he done said some things, did some things, and that kind of stayed away from drink Drake at that time. But I used to live in Canada when I was little, so I have no problem with Canadians, but I just feel like because you lost this rap beef, and I mean bad, you lost this rap beef bad, but never in my days have I ever witnessed somebody sue a record label because he lost a rap battle. It's it's beyond me. I don't know. And then by you even that's why I call him Paperwork Poppy now, because dude was sending out cease and desist letters and all types of stuff. I was like, dude, just take your loss and just go on. Like, you doing worse. When Chris Brown bodied Quavo, what did Quavo do? He went to country music. so So it's just like, dude, good morning, Mercedes. Good morning. All right, so let's hop right into it. Like I said, I don't want to take too much of y'all time on this Saturday. So this was actually filed yesterday. So Spotify did respond to Drake. Well, Drake's company, Frozen Moments LLC, because that's actually uh who filed suit against them. And here are their arguments. Like I said, we're going to go through the background and everything, but this is their argument. So first of all, it says petitioners section 1302C request should be because petitioner has failed to demonstrate any meritorious causes of action. So pretty much, bro, you don't have no proof that bots were hired. You don't have no proof that people, YouTube content creators and people at UMG and Spotify, that they were actually paid and to promote Not Like Us. You have no proof at all. So it says the petition fails to establish a prima facie federal civil RICO claim, and then B, the petition fails to demonstrate a prima facie cause of action under the New York GBL sections 349 and 350 and 350. So I'm just gonna hop right on so you guys can have a better understanding. So here's the preliminary statement. Good morning, Mary. Good morning. Issues of litigious interest. I don't know. I don't know what it is. Like Drake is just he's going out bad, and this is just making it even worse. So I have not read this. So once again, getting my live reaction with this. All right, so here's their preliminary statement, kind of giving us a rundown of what has transpired since the lawsuit, let's put it that way. So it says this proceeding arises out of a long running feud between the popular recording artist Aubrey Drake Graham, known as Drake, and Kendrick Lamar Duckworth, known as Kendrick Lamar. Drake, who is through his Frozen Moments, I guess, company, now contends that Universal Music Group, together with its affiliates, which owns rights to recordings by both Drake and Kendrick, worked with various third parties to unfairly promote Kendrick Lamar's Not Like Us, a song critical of Drake at Drake's expense. The petitioner speculates that UMG artificially inflated the popularity of the track through a number of avenues, including by using bots and pay play agreements, paying social media influencers song, and taking steps to conceal its scheme by allegedly terminating employees associated with Drake. Undercover of the far-fetched contention that this gives rise to a civil RICO claim, petitioner in this proceeding seeks to invoke the extraordinary remedy of reaction discovery. As to Spotify, a stranger to this fascus, the petition sets forth a single allegation on information and belief that Spotify agreed with UMG to discounted royalty rate for Not Like Us in exchange for recommending its users who are searching for other unrelated songs artists. On this basis, petitioner seeks pre-action discovery of the documents sufficient to show any such agreement and the financial benefits alleged received. So remember when we was reading the initial complaint and Drake made a mention, or Frozen Moments, whoever, stated that somebody asked, I think Siri to play Certified Lover Boy, and they ended up playing Not Like Us. I'm like, "What?" And then now, here's what Spotify is wanting. So you done said that we are paying people, that we're using bots and pay to play, and we done fired people that are associated with Drake, and that's not the case. So what they're requesting pre-action discovery, meaning that they are wanting the documents that you are using to claim that, because all throughout the petition, he stated that they had evidence. So since you have that evidence, go ahead before we start go any further and provide that evidence showing that we paid, people, or we used bots, or we did any type of pay to play. hmm Mary said it's like these game boards have changed, referencing the dynamics of technology and expectation. That is correct. You are very correct. Mm-mm. As set forth in accompanying affirmation, the predicate of petitioner's entire request for discovery from Spotify is false. There is such agreement. In any event, however, the petition is legally deficient and should be denied. Importantly, pre-action discovery under the CPLR 3102 requires, oh, I love when they do this. They actually put a link in there so you can actually go pull up the rule. But it requires a petitioner to first establish it as a meritorious cause of action. Boy, I can't read this morning. Here, however, petitioner offers only information and belief, speculations, rather than well pled facts. So you're just going off of speculation. You're not going off of facts. But since you stated in your petition that you have evidence that shows this, go ahead and hand them over. It also says, and this petition does not demonstrate how those speculative allegations make out the elements of the civil RICO, deceptive business practices, and false advertising claims petitioner seeks to assert. That shortcoming is particularly salient given that RICO claims are notoriously difficult to plausibly plead. Courts in New York uniformly holds that the CPLR under 3102C cannot be used to conduct a fishing expedition as to whether a cause of action exists, but that is precisely what the petition seeks to do. Meaning, Drake, y'all don't have no evidence. Y'all trying to get information. I don't know. I I really don't know. Because at first, when the petition came out, I was thinking, okay, well, maybe there are some people that, are inside, you know, Spotify and UMG, and maybe they're relaying information back to, Drake. That was my first thought. But y'all didn't include any of that in the petition. And you don't have to, but if you're coming out and saying that you have information, I would have put that out there. I'm just saying. Moreover, pre-action discovery is a narrow tool primarily used to identify unknown defendants where the petitioner has been harmed in a legally cognizable way, but lacks the ability on its own to identify the perpetrator. Here, however, petitioner does not contend that there are any unknowns as to Spotify. Petitioner purports to already know of an arrangement between Spotify and UMG and its relevant terms. Thus, even accepting petitioner's position at face value, which is, to be clear, Spotify does not, the petition seeks evidence necessary to prove rather than to frame its claims. That is precisely the sort of pre-litigation discovery that CPLR 3102C does not permit. For those reasons and those stated below, the petition should be denied. So, do I want to go? A little bit of the background says Drake and Kendrick feud and the petitioner's allegations. So this is kind of giving you guys an update as to, not an update, but a little glance as to why Drake ended up suing. Uh, Not Kendrick, but he ended up suing UMG and Spotify. Give me 1 second. Let me check on this bacon right quick. All right. No, I got to multitask. All right, let's get into it. All right, so over the course of 2024, Kendrick Lamar and Drake engaged in a highly publicized feud in which each released tracks with lyrics attacking the other, commonly referenced as a diss track. On May  4th, 2024, Kendrick Lamar released one such track, the single Not Like Us through Interscope Records, a division of UMG. Now, I did go back and I looked, and it's crazy because Drake is under the same, you know, division. So it's just like, why are you suing the same people you're under? But that track debuted at number one on Billboard Hot 100 song charts. Not Like Us ended its first week in 70.9 million official streams. The song has been nominated for 5 Grammy Awards, including Record of the Year, Song of the Year, and Best Rap Song. the wake of the artist's view, the petition contends that the success of Night Like Us is not organic, but instead is the result of a scheme by UMG. Mind y'all, the same label that Drake is under. The same record company that releases and earns revenues from Drake's tracks to deceive consumers into believing Not Like Us was more popular than it was in its reality. Specifically, the petition alleges that UMG launched a campaign to manipulate and saturate the streaming services and airwaves with Not Like Us in order to make the song go viral, including by using bots and pay to plays agreements. How and why do you believe this? It's just unnaturally like that song was like the theme song for the summer. It was like the anthem. It just did not affect the West Coast. It like I don't know. It brought unity to all 50 states. It was like us against Canada. I was like, Drake, be for real. The petition principally concerns actions purportedly taken by UMG and parties other than Spotify that petitioner contends amount to a civil RICO conspiracy and deceptive business and false advertisement practices. So anytime you have, these companies coming together and plotting against somebody, people always want to holler RICO. They always want to holler RICO. Mary says, the art of war enters a different battlefield for real. Let's see. It says UMG hired other unknown third parties to use bots to promote Not Like Us and also to inflate the streams of Not Like Us music video. Boy, when that video dropped on 4th of July, I knew I had an inkling that it was going to drop on that day. That was the perfect timing. And I promise you, probably like within 5 minutes, already had 1 million views. That was organic. I feel that it was organic. I don't feel that no bots, like, why? Like, why is it so hard for anybody? Now, if Drake would have done something like this and he got, big and all that other stuff, nobody would have came after him. But because you lost a rap beef, now you think somebody's conspiring against you to I don't know, take you out. I don't know. Let me see. Also stated that UMG engaged in a similar pay to play schemes to increase the airplay of Not Like Us on the radio. UMG employed a similar scheme by paying social media influencers to promote and endorse the songs of the video. UMG has been taking steps in the apparent effort to conceal its schemes, including but not limited to by terminating employees associated with or perceived as having loyalty to Drake. So all of those they claim. See, you making all of this, but do you have actual proof that they paid people, that they paid YouTubers, that they use bots, that they use pay to play schemes? The petition asserts no specific facts of any kind in support of these alleged RICO and deceptive practice violations. Instead, it relies exclusively on speculation, pled on information and belief, or the claims of anonymous individuals on the internet. On this basis, petitioner seeks discovery from UNG as well as an order requiring that UMG preserve all relevant documents and communications. And this is what they were saying. They were saying that Drake or his firm, Frozen Moments, were seeking discovery, and they also stated that they wanted to preserve all of the documents and communications between whoever, so that way they won't get rid of them and they can have. So, in my opinion, Drake and them don't have anything. Y'all don't have no proof whatsoever to back up anything that you said in this petition. That is why you're wanting, and I mean that's standard. That is standard to, say preserve all of the documents, preserve all the communications, and then when you get to discovery, you get all of that. But I am under the not conclusion, but under the presumption that Drake and them don't have nothing. They can't prove anything. I don't know. Maybe he thought that this lawsuit would scare them and then they would come forth and all this other stuff. I don't see it. I don't even see Drake having a case, to be honest. The petition allegations concerning Spotify. So, in regards to Spotify, it says the petition contains only three allegations that concern Spotify in a way. One, an assertion on information and belief that UMG charged Spotify licensing rates 30% lower than its usual licensing rates for Not Like Us in exchange for Spotify affirmatively recommending the song to users who are searching for the other unrelated songs and artists. Two, citation to an assertion by an unknown anonymous individual that he was paid by Interscope to use bots to to achieve 30 million streams on Spotify in the first days of the release of Not Like Us, and who allegedly said Spotify was the easiest platform to bot because it lacks certain security measures. So if you said that there is an individual, who is that individual? That's why Spotify is like, now we need to go through pre litigation discovery and figure out, you hand over what you have to us, because who's these individuals that you're saying that you're claiming were paid? The third allegation was again on information and belief, no actual facts, that UMG paid or approved payments to Apple to have Siri misdirect users to Not Like Us on platforms like Spotify. Correct me if I'm wrong, but didn't they say that Drake was the top? He got some Spotify thing, and I think I seen it. I thought it was fake for a minute, but said that Drake was the top number one global artist or something on Spotify. And I was like, that can't be true. That can't be true. I think Spotify did that to make that man happy. But uh so this is the allegations against Spotify. So saying that UMG charged Spotify licensing rate 30% lower than its usual rates. The second allegations was that an anonymous individual is paid by Interscope to use bots. And then the third allegation was that UMG paid Apple to have Siri direct users to the Not Like Us song on platforms. That's what I was saying. When you say, "Hey Siri, play Certified Lover Boy," it would play Not Like Us. Based on these allegations, the petition seeks pre-action disclosure from Spotify of the documents and communications sufficient to show the dates, methods, and the amounts of financial benefit provided to Spotify by UMG Interscope in exchange for the promotion, publication, or recommendation of the song on Spotify, if any, and two, what Spotify agreed to prove and did prove in exchange for such alleged financial benefits. The petition alleges no facts supporting the petition's information and belief and hearsay assertions, and two of the three are not even related to the relief sought by the petitioner. The sole allegation in the petition that actually pertains to petitioner's requested discovery from Spotify is the information and belief assertion that UMG charged Spotify lower licensing rates for Not Like Us in exchange for Spotify to affirmatively recommend the song to users who were searching for other unrelated songs and artists. Like, why would people go through that great death to do that? Like, if I say go play Busta Rhymes or something, no, I don't get it. I really don't get it. Let me see. Oh. Let me see. Oh, us in Canada also effective triangulation polarizers, also tactics of war. Though Payola is old as the TV. They were diverted. Two numbers were inflated. Seem I wish Kendrick and his girlfriend was sue Drake. Yeah, and here's the thing, and that's the why not go after Kendrick? Why not go after Kendrick? I thought I had something else to say, but why not go after Kendrick? I guess you're gonna. Why go after the company that you're also with? Makes absolutely no sense. Let me see. Where is that? As set forth in a company affirmation from Spotify employee David Kafer, however, Spotify and UMG has never had any such arrangement. And so he even put his affirmation in there. So he's saying that Spotify and UMG never had any arrangement that you are here alleging in your complaint. And so David Kafer actually put his affidavit and to make it known that Spotify and UMG does not have any other outside agreements other than what they have as, Spotify playing music. And that's it. Nobody, UMG is not paying Apple. UMG is not, paying Spotify under the table to no, it was none of that. And guess what? When the Super Bowl comes, what is Drake gonna say now? Because when the Super Bowl comes, Not Like Us is going to blow right back up. It's going to blow right back up. This is all organic. What I'm thinking, it's all organic. How hard is that? Because you lost a rap beef, you take it in. Let me see what else it says. The other allegations that mention Spotify do not allege any relevant conduct by Spotify and do not bear at all on discovery that petitioner seeks to commit. Specifically with respect to petition's assertions regarding alleged Siri misdirection, the petition does not allege that Spotify had any alleged payments arranged with UMG or Apple, nor that it was aware of any such arrangement between those other parties. Similarly, as to the unknown individual, here's the individual that they're talking about. Let's see. So, similarly, as to the unknown individual who claimed that Spotify is easy to buy and purports to have received compensation from Interscope to artificially inflate streams for Not Like Us on Spotify, the allegation concerns dealings between parties and not including Spotify. All right, legal standard, argument. So let me see. So they're stating that his request should be denied because he failed to demonstrate any meritorious causes of action. So discovery under so Drake's what they're saying is Drake's request for discovery should be denied because he has no merits. So discovery under the 3102C is typically granted only where the facts establishing a cause of action are clear, but the identity of the alleged wrongdoer cannot be established without pre-action discovery. They cited what is this, Diaz versus Metro, where it says granting pre-action discovery where the facts alleged by the petitioner states a cause of action and the discovery that he seeks is limited to obtaining the identity of prospective defendants. Because if they don't know who paid, like, you're not giving any names, so who is it? You stated that somebody paid such and such to do such and such, but you didn't provide any names in your petition. So how can they, provide any documentation to you when they don't even know who the person you're speaking on? Indeed, the First Department repeatedly has held that pre-action discovery cannot be used to determine whether a cause of action exists or for the purpose of exploring a possibility of alternative theories of liability or whether the prospective plaintiff has a cause of action worth pursuing. Let me do precisely what the petition seeks to do here. And then they cited Thomas versus MasterCard, as well as GTV Media Corp versus Confidential Global Investigations. In that case, it says pre action discovery is not permissible as a fishing expedition to ascertain whether a cause of action exists. And then Halsman, it states that pre-action discovery cannot be used as a prospective plaintiff to assertion whether he has a cause of action at all. Oh my gosh, this is crazy because petitioner cannot demonstrate that it has any meritorious action, cause of action. There is no basis under the CPLR to burden Spotify with pre-action discovery, and the petition should be denied as to Spotify. So he states the petition failed to establish a prima facie of a federal civil RICO claim. You have no proof that UMG and Spotify were in cahoots to bring you down. Petitioner purports to have a cause of action for civil RICO against UMG and not Spotify. But the petition clearly fails to set forth sufficient facts to support a prima facie cause of action. To state a civil RICO claim based on a violation, petitioner has to do the following, or allege the following. They have to allege conduct of an enterprise through a pattern of racketeering activity, as well as injury to business or property as a result of the RICO violation. They cited a couple of cases, and it says internal quotation, da da da. Okay, racketeering activity is defined to include various predicate acts, including mail and wire fraud. They kind of give you guys like an example. Think about Diddy's case. Like they have evidence showing that he paid individuals for certain things across state lines. Cause y'all, they have what about, I don't even know how many terabytes of information with that, but they have all evidence. They have his businesses. That's why when y'all see these lawsuits, you see Combs and all his Bad Boys Entertainment and all that, because they actually have proof that there was some type of racketeering activity that was going on. Here in this, Drake has nothing. Drake does not have any receipts. He doesn't have anything that shows that there is RICO activity. You're just all throughout the complaint, you're saying on information and belief, or an anonymous individual said this, but you're not providing any receipts for that. So how are you going to come through here and say Spotify had anything to do with it? Now, Spotify can only speak to Spotify, and Spotify can only speak to their relationship with UMG. So they don't know what, UMG got going on, but they can only speak for themselves. It is rare for any plaintiffs to be able to state a prima facie civil RICO claim. Courts have explained that civil RICO plaintiff almost always miss the mark because of the difficulty of demonstrating these elements and the formidable interest. I'm not even going to read that word. And pitfalls inherited in RICO litigation. In addition, whereas here a party asserts a claim predicate on mail and wire fraud, it must meet the heightened pleading standard Rule 9b. In Intratellis Americanas and Solar, it says that the overwhelming trend among courts is to apply Rule 9b strictly in order to effect dismissal of civil RICO suits alleging mail and wire fraud. The petition is no exception. It fails to set forth facts showing basic elements of the claim and fails to articulate any viable theory of RICO causation of injury. Any of these defects is independently sufficient to defeat any showing of a meritorious RICO cause of action. So you failed to articulate any type of RICO causation or injury to you, Mr. Drake. The petition fails to establish the necessary predicate fraud claims. In fact, petitioner concedes that it cannot plausibly state a RICO claim on the basis of its assertions and that it seeks pre-action discovery in order to be able to satisfy heightened. So here in the complaint, he came out and said, and I said Frozen Moments came out and said that they can't possibly state a RICO claim because they don't have that information and they need that information. So they need the documentation and the information and the documents from Spotify and UMG in order to go through and see if there is indeed a RICO claim. So they're just alleging a lot of stuff, and for them to actually make it stick, they're requesting the documents from UMG and from Spotify to go through and say, okay, all right, I can take this information, I can use it. And then that's when they will actually amend the complaint and state their RICO claim or whatever claims that they're trying to make. Just kind of like in Megan the Stallion's case with is it Malagra? Milagro Grams. You know, Megan filed suit. Then Milagro, she ended up filing a motion to dismiss because plaintiff failed to state a claim. And then Megan came back and filed an amended complaint and stated her claims for defamation, cyber stalking, and all that other stuff. Right. And so in this particular case with Drake, Drake is saying, okay, we know that there's some type of RICO activity, but we can't determine that for sure unless we have all of the documentation and proof from Spotify. So we need for them to preserve whatever documents that they have, because they might try to get rid of them, blase, 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 blase. And then once they go through all of that, then they can come back and amend a petition in order to state each claim that they're pretty much alleging. So they can't say anything about RICO and all the other claims that they're mentioning because this is just based off of what they call hearsay or information and belief. Let me see. What they say. In fact, da, 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 uh, where are we at? Even absent petitioner's concession, it is obvious that petitioner has not alleged a prima facie mail or wire fraud violation. To do so, petitioner must identify a specific fraudulent statement. So they cited, these are some weird names. They cited this case, and in this case, it says dismissing mail and wire fraud claims where plaintiffs did not specify statements they claim were false or misleading. But while the petition generally asserts that consumers were misled, it nowhere purports to identify a specific false statement made by any respondent, much less the contents of the allegedly fraudulent communications, who was involved, where and when they took place, and why they were fraudulent, and as would be required to meet the requirements. So just like the example that they used in the petition when somebody said um they requested Siri to play Certified Lover Boy and they played Not Like Us. They didn't get they That was all that they said. They didn't give any other information of who did it, where they did it, when they did it, where it took place, and why they believed that it was fraudulent. They didn't do any of that. So I think they just put a petition together and filed it in order to scare somebody. I don't know who they thought they was about to punk, but Spotify is shutting them down. The petition likewise fails to identify any facts supporting other elements of the mail or wire fraud predicate acts, including, for instance, a scheme to defraud or a scienteer. Um, the petition also fails to demonstrate any viable theory of RICO causation and injury. To satisfy this particular statute for RICO injury requirement, a concrete injury to the individual's business or property must be alleged, Reputational harm alone is not enough. So, Drake, just because you lost this rap battle, you can't sit here and scream Rico if it did not cause any other injury to you. Did you see a dip in your sales? I mean, your feelings are hurt, and you probably can't be with any other artist because you're too embarrassed. But what other injury did you have? How did it affect your business? You didn't even include any of that in your petition. How did it affect you business wise? And the losses to one business or property must be quantifiable, not non-speculative. So you can't speculate anything. Like, you have to show you lost millions and millions and millions of dollars because of what happened. The plea causation, a party must show that a RICO predicate offense is not only a but for cause of the alleged concrete injury, but also the proximate. In other words, a party seeking relief under the civil RICO statute must show that the alleged violation led directly to the plaintiff's injuries. The only injury the petitioner purports to identify is unspecified, diminishing revenues. That assertion is neither concrete nor quantified. So you just said unspecified diminishing revenues. You didn't provide a number. You didn't say, well, I lost, 100 million, or you just said unspecified diminishing revenues. Love your report. The only thing I can see that may have injured Drake is the PDF. But here is the thing with that. If we look at it, I don't even think what let me see. He said Baca got a weird case. Why is he around? Certified lover boy, certified da da da. I don't even think that was even directed to Drake. I think that was in reference to Baca, if you want to be real with that. That's what I'm thinking. That's what I'm thinking. Maybe it's a publicity stunt. Reference as to why the petition forwarded. And you know what? It could be because he has announced, like, and it's weird because y'all have to think about it. Kendrick is doing the Super Bowl, right? I think Drake is trying to put something in place so that, and this is my theory, so that Kendrick will not perform this song at the Super Bowl. Do you know how many people is watching the Super Bowl, y'all? So Drake is trying to get something in place to where Not Like Us is taken down and can't ever be chanted across the globe ever again. So he's doing this lawsuit, saying that he's on tour in Australia. I don't think really people even care. I mean, every now and then I sing my little Drake songs and stuff like that. Cause I mean, he was. I mean, the song. I ain't gonna say he, cause he had a ghostwriter, I'm assuming. But I don't know. I think he's just trying to get Not Like Us off of the map. Cause if Kendrick go on that stage on February 9th and saying Not Like Us, and the hype is gonna be lit, like that is like it buried Drake. He was resurrected, he got buried again, he was resurrected. Is that is his fear. So him, by doing this petition, did him no justice at all, because really Spotify is picking him to pieces. Like, you can't say that your revenue has been like diminished, and you're not putting a number. What do you have to present to the courts that you are affected by a song that you believe was promoted through bots and pay for plays and all this other stuff? Where is your evidence? Where's your numbers? How were you affected? You show no injury here. You're saying it, but you're not providing any evidence that it actually happened. That's why they're saying in order to do to claim any type of RICO, where's the numbers at? Oh, excuse me. Had to get okay. Let me see. That assertion is neither concrete nor quantified. The petition simply theorizes that streaming and licensing is a zero sum game in which every time a song means another artist does not. I remember that they said this as well. So you're saying because Not Like Us broke the charts, you like what? You didn't like you I believe, if I'm not mistaken, you were still in the charts. Like people were still recognizing you. You still have fans out there. I didn't see you crying like Swift. She's always on top. She's always number one or two. I don't see anybody out there filing a lawsuit claiming that, because the song came out and is very, very popular, the other artists, we don't get to shine. So let me file a lawsuit against Taylor Swift. I mean, it's just childish and petty at this point. Let me see. So in his petition, he asserted that the alleged scheme artificially boosted the popularity of Not Like Us, in turn, supposedly reduced the popularity of petitioners' music, which in turn allegedly diminished petitioners' revenues. Okay, by how much, my boy? How much was your revenues diminished by? The petition does not cite evidence that Drake's music became less popular, let alone purported to identify by how much. In fact, Drake was the second most popular artist on Spotify in the US in 2024, behind only Taylor Swift. So, how did you become less popular? Even had petitioner identified a concrete quantified reduction in petitioner's revenues, however, petitioner's causation theory is not cognizable. Oh my gosh, under and fails to set forth a prima facie claim for civil RICO. Because the petition fails to account for a wide array of intervening factors that could have caused any revenue decline, the chain of causation that is lacks the direct proximate causal relationship required to state a RICO claim. Let me see. And they said it, they cited a case, Anza, that stated rejecting RICO causation theory that plaintiffs suffered a loss of sales resulting from the defendant's decreased prices for cash paying customers because plaintiff lost sales could have resulted from factors other than petitioners' alleged acts of fraud. Businesses lose and gain customers for many reasons, sir, but you were still at the top. So what what I'm just trying to figure out what loss did you incur at this point? This man is butthurt. At bottom, petitioners' RICO theories suffer from multiple independent legal and factual failings. Because the petition does not demonstrate a meritorious civil claim, it cannot warrant burdening Spotify with a pre-action discovery under the CDLR 3102. So you don't state a RICO claim. So therefore, Spotify shouldn't even have to deal with providing you with any information. Let me see. Petitioner claims under GBL section 34(9) and 350, 358 better. Under both sections, petitioner must demonstrate the same elements. So you have to demonstrate the act or practice at issue was consumer oriented, it was deceptive or misleading in a material way, and that the plaintiff was injured as a result of the alleged deception. Petitioner once again fails to demonstrate these elements for much of the same reasons that it fails to demonstrate the elements of his civil RICO claim. As described above, petitioner fails to identify any specific misleading, misrepresentation, or omission alleging made by any of the respondents as it must to state a claim. As explained above, the petition does not establish any decline in the popularity of Drake's music. People are still out here bumping Drake. They still play Drake's on the Drakes. They still play Drake on the radio. I'm just trying to figure out, are you saying that people don't want to work with you? Or I don't know. What else? And it says, and even if petitioner could show a decrease, there's no fact sufficient to causally link it to the success of Not Like Us or suggest that the decline in popularity of Drake's music was the direct result of any alleged deception rather than the host of plausible factors. Like they're saying, if you are seeing a decrease in people playing your music, or if you are seeing a decrease in your revenue because your music are not getting played, or I guess people not working with you, or so on and so forth, those are other factors that has nothing to do with Not Like Us spiraling to the top. And even if it did, you don't have anything to show that it's a link to that. This man, he's doing too much because petitioner has not met its burden to demonstrate any elements of the section. The petition should be denied. Let me see. Even if he was to state a claim, pretty much, the petition only can be granted if the information sought is material and necessary to the actionable wrong. This requirement has narrowly interpreted by courts resulting in CPLR 3102 being used primarily to identify unknown defendants where a petitioner has been harmed in a legally causable way but lacks the ability on its own to identify the perpetrator. Let me see. He's not disclosing. Drake doesn't have anything. Y'all sitting there and saying that YouTube people were being paid. Somebody through Interscope was being paid, but you don't come out with a name. You don't name. He doesn't know anything. That's exactly why he's asking for pretrial discovery. Here, the discovery that petition seeks from Spotify is plainly not for the purpose of identifying any defendants. Petitioner purports to already know. Oh, and that's another thing. So you saying that you know that there's an arrangement between Spotify and UMG, as well as the payments UMG has allegedly made to third parties for a promotion. So the way that the petition is written is like you already have these facts and you already have this proof, but yet you are needing more from Spotify and UMG. Thus, even accepting petitioner's position at face value, the evidence that it seeks is not for purposes of framing a claim, but instead for the purpose of proving petitioner's claims or identifying new theories of liability. That part is very important because it is the job. Whoever, if you file a lawsuit against anyone, you are responsible for proving your own claims that you are making. I repeat, if you file a lawsuit, the burden of proof is on the petitioner. So just like Spotify just said, I'm going to reread this. It says, even accepting petitioner's position at face value, the evidence that it seeks is not for purpose of framing a claim, but instead for the purpose of proving petitioner's claim or identifying new theories of liability. Because normally, as I always said, you have the burden of proof. You have to provide all of this. When you go through the discovery phase and you get the information and the stuff that you need, you're just in a sense supporting your claim, but you don't have anything in your possession to prove anything that you have put out against UMG and Spotify. So Drake is relying on any and all information that UMG and Spotify has. So technically, he doesn't have anything. He's just hoping that he could get what they got and say, okay, I could prove my RICO claim or I could prove this. And if they find anything additional, then they can add new theories of liability there. Spotify's like, no, we're not about to do that. This is precisely the sort of discovery that the CPLR does not permit. In compare Holzman, it states that denying petition seeking to inspect a bus on which the petitioner slipped and fell, where petitioner already could have identified the defendants, the bus route, and the time and place of the accident, and therefore has sufficient information to frame his complaint. All right. So in this particular case, the petition was like, okay, I need to see I need to get the bus. I need to inspect the bus. So I guess it was a slip and fall case where the petitioner slipped and fell, right? So when you made that slip and fall complaint, you would have already known what bus you was on, what route, the time of day, the place where it occurred. But he didn't have any sufficient information. So that lets me know you probably wasn't even on the bus. You trying to inspect the bus and then you're going to come up with all this other stuff. It don't work like that. That's funny. That is crazy. Lemon juice versus Twitter. In this one, it says compelling Twitter to produce identity of account owner so that the petitioner could identify the appropriate party against whom to assert claim for intentional infliction of or emotional distress. So you're claiming emotional distress of somebody you've been going back and forth with on Twitter. Huh, I need to look at that case. That's interesting. I'm sorry. Champion and Metro. Let me see. Compelling discovery of the identity of a motor vehicle operator where identity of the operator was necessary for framing the complaint, but denying requests to inspect respondents' vehicles and plows. These are interesting cases. Indeed, the discovery sought from Spotify is the kind one would expect to see following the filing of a lawsuit, whether in the form of party or third party discovery. Courts frequently deny pre-action discovery petitions where the requested information is more appropriately sought through normal discovery channels. Let me see. What petitioner is seeking to do here, then, is to bypass the normal pleadings requirements attendant to civil litigation, including notably the heightened pleading standards applicable to civil RICO claims alleging mail and wire fraud, and obtain by way of pre-action discovery that which would be entitled to seek where it survives a motion to dismiss. The subversion of normal judicial process should be rejected. For the foregoing reasons, Spotify respectfully requests that the court deny the verified complaint as full against Spotify. So I read all of that, all 18, 19 pages. So in sum, Drake has nothing. Drake has absolutely no factual, tangible information or documents to back their claim up in regards to Spotify. And I'm pretty sure UMG's answer is probably going to be similar to this. You have nothing. You made claims based on information and belief, hearsay, and anonymous people who I'm assuming worked with UMG and Interscope. But that, once again, that had nothing to do with Spotify. But you're trying to holler a RICO claim and state that your revenues were diminished, but you have nothing to show for that. Like, we all seen Spotify state that you were number one or two or something on the Spotify billboards for the 2024. So exactly how were you injured? Drake has nothing. I honestly do not see this case moving forward. I really don't. I absolutely do not. And he's trying to holler Rico. Hmm. I wish no. Yeah, I think he does need to Spotify. They need to be dismissed from this and UMG. Cuz I'm just thinking, if we go back to the petition, y'all, for real. He made no factual claims in there. Well, he alleged some things, but he didn't provide supporting documentation or information, if that makes sense. Just like when he said somebody, he didn't give a name or date that this person stated that they want to hear Certified Lover Boy and they play, whatchamacallit. You could just make that up out of thin air. Or, you saying that your revenues were diminished. All right. You didn't put anything in that petition to show, okay, in 2003, I made this. In 2002, I made this. But here, 2004, I supposed to make this, but I didn't because of this. So it wasn't supportive. Drake is really hoping to get information from UNG and Spotify in order to support his claim. He's wanting them to do the work for him instead of him doing the work for himself. You file a lawsuit. Did nobody tell you how this works, Drake? Your feelings are just hurt, and you are trying to bring the song down so that way it can never ever be played again because your feelings are hurt. I'm sorry if y'all are Drake fans. I am truly sorry. I used to be a Drake supporter. Before this, I stopped. Like, before all of this went down, I stopped listening to Drake. I mean, I sing his songs every now and then, but this move that he pulled was very crazy, and Spotify shut him down because your whole petition is just a bunch of information and belief and hearsay. You don't come with any facts. Take us out of the group chat. If you really feel that your reputation was harmed, why didn't you go after Kendrick? Why you and I understand, because UMG and Spotify, those are the real money makers right there. But you risk everything. You risk being, but I don't think UMG is going to drop him. But that's a risk that you have to take. And even UMG said it. Like, why are you suing in a press release? Why are y'all suing us? Why aren't you suing Kendrick? That's the person that really, if reputational harm, that's the person you need to go after. But Drake ain't gonna do that. Drake trying to go over. Drake went to the supervisor. No, it was Drake went to the CEO. He didn't even go to the supervisor. He went to the CEO because he know the CEO will possibly shut it down. No, but you throwing out all this fake stuff. Somebody hired this. Somebody was paid here, and all this other stuff to do this, this, and this, and this. But you have no facts. And people, it's crazy that people be like, yeah, I believe it. I believe bots. Who? How? Now, I know bots can be paid. Now, how you do it, I have no, not be paid, but you can buy bots to do some stuff. But I don't know how to do that. But if you say you have proof, show that in your complaint. That will make it look a little bit better. amend your complaint and state your claims. Because if they file a motion to dismiss themselves, just themselves, Spotify, then I'm pretty sure it's going to be granted. And then you ain't going to have no case. But yeah, so I know this is a weird one, but Drake is just in his feelings. And I just can't wait till February comes because and just like I haven't even checked to see the billboard for Kendrick Lamar. Like he just dropped his album and like we're playing it crazy out here in Dallas. I don't even know where he's at on the charts. But are you going to file a lawsuit and include that in the lawsuit that because, everybody is bumping Kendrick Lamar that your revenue is hurt, your reputational harm you suffered? I don't know. But hey y'all, thank y'all for tuning in. Let me see. The song becomes collateral damage, never to be played again. That is deep in the art of war. Yeah. Let me tell you something. That song, Not Like Us, will always be an anthem. I don't care. Every time I hear that song come on, I don't know, it just does something. But I think that it was organically. Oh, his album is definitely on the high charts. Yeah, that's what I'm saying. Like I've always been a Kendrick Lamar fan. I just did not start hopping on the Kendrick Lamar train. 2024. I've always listened to Kendrick Lamar. Whole album. And my kids listen. They was like, yeah, my oldest was like, if you listen to Kendrick Lamar's album, like from beginning to end and then to the end backwards, some type of theory he done came up with. And I was like, man, I never thought about that. But Kendrick, it is. Like, we don't hear from Kendrick that often. We hear him in features. But as far as, coming up with an album or, just a song, that's all we hear. But Drake, he always coming out with something. So he's always around. So I don't know. And this is just my thought process. It's just like, oh my gosh, when you haven't heard from your favorite artist in a while and they come out with something, it's going to be huge. And yes, people are going to be tuning in. But I'm thinking because this beef has been brewing for years. It has been brewing for years and it just came to a head during the spring, and that's it. That's all. Some people are, those one-hit wonders, they accept the fact that they made one hit and they go on about their business. So Drake needs to go ahead and accept the fact that he lost this rap beef. Go on about your business and like Kendrick said, keep making us dance. That's all you got to do, my boy. That's all you got to do. But hey y'all, thank y'all for tuning in on this nice Saturday. I hope y'all all have an awesome Saturday. I may come back on later. It just all depends. I know there's something I wanted to talk about. Something with Jay-Z and Tony Busby, because I remember when I read that letter that Busby responded yesterday, and he spoke on he cited a case. What was it? It was a Pasoli versus the Roman Catholic Archdiocese of New York. I found the case and I thought it was very, very interesting. The fact that he cited this case because the allegations in that particular case were somewhat similar to the allegations in the amended complaint that Tony Busby filed for Jane Doe. So I thought that was interesting. So I might discuss that with y'all tonight. It just all depends. But hey, y'all enjoy the rest of y'all Saturday. If I don't see y'all later, y'all be blessed. Stay safe out there. If you're traveling, definitely be safe. And I will catch y'all later. Bye.